Welcome home, y'all. I hope you're not sick of me. I just had a live episode yesterday, trying to break down everything that's going on with the attacks on Black women that coming from the highest office in the land. Again, this is Native Land Pod. I'm your host, Angela Rye. Today, we are having an incredible special edition live stream conversation with someone who I just truly admire and adore. As you all may know, before the Supreme Court of the United States today, there was a case, Louisiana versus Callais. And in this case, at issue is whether or not a majority Black district in Louisiana is now, in fact, unconstitutional, talking about whether or not Section 2 of the Voting Rights Amendment violates Sections 14 and 15 of the 14th and 15th Amendments of the Constitution. Here's what I want us to know. We are in really, really perilous times. And in these perilous times, the folks who are fighting these battles most often look like me. They are Black women. And this sister is no exception. I learned some time ago that she would be making the oral arguments before the Supreme Court in Louisiana versus Callais. And I'm going to save all my fanning out for when she joins us just now. She is the president and director counsel of the NAACP Legal Defense Fund. Her name is attorney Janai Nelson.
Hey, Angela, how are you?
Hello, my dear sister. So I got to tell y'all, I got a call from the comms folks at LDF, and they said, we want you to know you can't say anything. Janai Nelson will be arguing. She will be bringing oral arguments in the Supreme Court case in Callais. And I started crying. Janai, I was so happy. I was so happy because,
I
it's
probably
been.
started crying too.
Well, I hate that you had to, this case had to be re-argued, and we'll talk about this in just a moment. But what I loved is I knew there was not a better fighter, someone who had more command of the facts or the law, someone who I know would not only make the ancestors proud, but be protecting the interests of future generations, someone that would tell the truth about what this country is and the growth it has to, undergo, and certainly what is still at issue, whether we like it or not, in the state of Louisiana. So I was thrilled about it. I was like, tell me what I could do. It's not just about Native Land Pod, but we welcome her here. But I wanted to make sure that our folks know you exist. Sis, I think you deserve a whole Barbie doll at this point. Okay. I am serious. This is our generation's Thurgood Marshall. Don't be surprised if one day, as long as democracy does not crumble, that Janai Nelson will also be the other sister with locks on the bench. Okay. So I just want to say thank you.
Oh, thank you, Angela. I really appreciate all that loveliness. And, I've been a long admirer of you. We've been doing a lot of work these past, what is it now, 10 months of absolute chaos and war. And I just could not ask for a better partner in the fight. So thank you for everything that you and Native Pot are doing.
Thank you so much, sis. Well, here's where I want to start. I think I don't want to skip straight to what happened today in orals. I did hear your oral arguments again. Like I'm like, there just was nobody better. But I want to ask you just how you're feeling on the other side of standing before the Supreme Court. There's so much at play. We're watching the dismantling of our rights happen in our cities, in our states, all over the country. You're standing in the heartbeat of it all, walking into the Supreme Court, knowing that there was once upon a time some folks came down those steps with a victory. And now it feels like all of that is hanging in the balance, and it has the nerve to be hanging in the balance. The 60th anniversary year of the Voting Rights Act. Now, this is something I know you've heard me talk about before, and I know you talk about often, and that is like the way of the Voting Rights Act. I think this is important context for folks. And then I did ask you how you were feeling, so I want to get into that. But on in 1968, when the Voting Rights Act was initially passed, HR 6400, that was passed in July of 65. It was a 333 to 85 vote in the House. In the Senate, it was 77 to 19. So overwhelmingly bipartisan in 68. The Voting Rights Act is reauthorized in 1970, in 1975, in 1982, and in 2006. And up to 2006, in the House, 390. So more people More Democrats and Republicans and independents voting to support the reauthorization of the Voting Rights Act. I did not stutter, y'all. It was 2006, 390 to 33. And in the Senate, it was a unanimous vote, 98-0. Again, this was in 2006. Something has happened. We don't know what. We're not going to allege anything, at least not with my sister on. Maybe I'll wait till she gets off. But something happened from 2006, I don't know, maybe a 2008, a 2012 election. And in 2013, the Supreme Court takes up the Shelby versus Holder case, essentially gutting sections 4 and 5 of the Voting Rights Act. And today, at issue again, because this isn't the first time, Section 2 of the Voting Rights Act is up. We're going to get into all that. But Janai, first, how do you feel on the other side of the arguments? And what do you think the path to victory looks like here?
Oh, listen, as uh, intense as it has been, I am feeling so extraordinarily energized. I am feeling buoyed by all the amazing people who came out to stay in front of the Supreme Court, to chant, to dance, to hold signs, to make their voices heard, and to make it clear that we are not going anywhere, that this democracy is ours. We helped to build it. We will fight for it, and we will win. We will win. There are many paths to victory, but what's wonderful about this particular case, the path to victory is pretty straightforward. It's called following precedent. It's called follow the law as it is. Don't try to change it. Don't try to tweak it. It's been working well. We've made extraordinary progress. The work of the Voting Rights Act is far from done, but we have carried this multiracial democracy forward for 60 years. We're celebrating, as you said, the 60th anniversary of the passage of the Voting Rights Act in 1965 this year. And this is no time to try to turn the clock back. We're seeing, more assaults on the right to vote. We're seeing all sorts of ways in which our democracy is being manipulated by people who claim to be leaders of this country, by political parties, and just by white supremacist extremists. But we're here to say that we built this thing, and we are going to defend it until we possibly until we win. Period. That's that.
That's it. We built this joint for free. That's what we say around these parts. And I will say, you know, what I think is surprising in this case to me of course, that issue is Louisiana and this second majority black district that was drawn that is now occupied by Cleo Fields.
Mhm.
Part of Cleo Fields district includes Baton Rouge. Baton Rouge, the same Baton Rouge, where I believe it was East Baton Rouge, where they attempted to essentially secede from the rest of Baton Rouge. This is the white part trying to separate from the black part. What I think is fascinating here is Louisiana's black demographic is 32.8% according to the 2020 census. Nearly 1.5 million people in the state of Louisiana are black. That's higher than Alabama and Arkansas. Alabama, the Supreme Court upheld. There was an Alabama case where the Supreme Court upheld Section 2. Shreveport has a 57.8% black population. New Orleans, 57.2. Baton Rouge, 52.4. They say somewhere between 52.4 and 53.5. Today, Janai, you were arguing before some Supreme Court justices who were challenging whether or not race should still be an issue when you're saying clearly there's a pattern and practice of white folks failing to vote for a black person, a black candidate, what regardless of what side of the aisle they're on. There is this clear pattern, and they're arguing like, well, do we still need to consider race? Should this be a remedy? And I was fascinated to hear that when you consider just the demographics of the cities we just laid out, they would be lacking in representation in Shreveport and Baton Rouge. It would only be New Orleans that would have, unless they redraw it so that it encompasses all this. But then what does that map look like? A garden snake?
Exactly. Listen, you laid it out. You could have been up there with me. The facts are so clear in Louisiana. Of all states, Louisiana is not the one to be the vehicle for narrowing Section 2. In fact, it is the poster child for why we actually have Section 2. So, as you rightly point out, Louisiana has the highest percentage of Black people of any state in the country outside of Mississippi. right? So black people are about a third of the population. And the reason that we brought our suit initially was because even though black people were 33% of the population and the white electorate is steadily declining year after year, they were in control of 83% of the congressional districts. They occupy 58% of the electorate, were in control of 83% of the districts. That alone should tell you something is not right. But we know the Voting Rights Act does not guarantee you proportional representation. You can't just go in there with the numbers and be like, give me another district. You have to explain that the reason we don't have a district is because of race. And there's a whole set of factors and a lot of proof that you have to put on to establish that. And we did that. And a federal court said, okay, we've heard your witnesses, we've read your evidence, we've looked at all the arguments. You're going to win this claim if you keep going at it. So why don't we stop the state right now and say, you know what, this is not looking good for you. This looks like discrimination. You need to draw another map. They appealed that. Another panel of judges, this time appellate judges in one of the most conservative circuits in the country, the Fifth Circuit, said, yeah, we agree. This is a unanimous panel. Appealed again, another unanimous panel. So at this point, we've got 7 federal judges in the Fifth Circuit saying this looks like discrimination because Louisiana is drawing maps, and every time they say they want a map that doesn't have precinct splits or that respects certain communities, we said, okay, bet. Here's a map that does all that, and it gives black people a right to vote in another district. You want this particular, equal population? Bet. We got a map for that. We had a map for everything they asked for. We had a map for that. So we put on 7 different maps, and Louisiana looked at all 7 of them and saw that we had an extra black district in there and said, you know what? Actually, we'll pass. And so that's the type of discrimination that we're talking about. It doesn't anymore happen with people saying, we don't like black people and we're trying to, cut you out of power. It's much more complicated, much more subversive, and it requires a lot more resources and litigation like the kind we brought to suss that out. So that's what we had to explain to the court today. And we were really defending the map that we won against a challenge from some white voters in Louisiana who were now saying that the fair map that we got drawn, the one that elected Cleo Fields in 2024, they're saying now that map somehow is unfair to them, even though if we go back to numbers, they're 58% of the population. They still control like 66% of the congressional district. So they are still represented super proportionately, and yet they're crying foul.
Yeah, and I think that that is also another big part of this, like the significance of this case. Louisiana was up today, but folks are relying on how the court rules here to determine what happens with these other maps. We know just over this year they have done this midterm redistricting processes in Texas and in Missouri, and talking about it in Indiana, and they are hoping on a wing and a prayer that the court will eliminate Section 2, because that pushes all of these maps and this, kind of this midpoint redistricting forward. The Congressional Black Caucus has 63 seats right now. One is vacant because Governor Abbott has refused to fill Sylvester Turner's seat after his passing. May God rest his soul. But they're talking about upwards of 30 Congressional Black Caucus seats being in harm's way if Section 2 is eliminated. Janai, what hope can you give to people when you consider just your experience today and what you were arguing? One thing that I was encouraged by, because I think some folks need to hear it, as much as I don't mind talking about race and facing racism, the panel clearly did. So one of the things you had to say in orals today was not all of Section 2 remedies center race. Can you talk a little bit more about that and what other remedies folks can rely upon, and why it's so important not to just blanket say we don't care what state it is. Section 2 is not here anymore. We don't need it. That's it. It's just an overreach. But I want to hear your thoughts.
Yeah, that's right. So, I think the court has said over time it has expressed some discomfort in the use of race, although it is lawful under its own precedent that if there is a clear and specific violation that's based on race, you can use race to fix it, right? That makes sense. It all is quite logical. That said, to the extent that they are embracing, and we embrace too, the ultimate goal where we have a political process, an electoral process where race doesn't play a role in who wins and who loses, we want that too. And I think we just differ on how we get there. And what was really at play today was, how much can you use race? And was race really the driving factor in how this map was created? And our position was this: listen, we think the map that elected Cleo Fields, we think the map that the state drew is actually constitutional. There's a solid argument for why it passes one of the toughest tests in our law, which is strict scrutiny.
Mhm.
But we also are saying, listen, we don't really care what map remedies the violation. If you have a map that doesn't take race into account and you can still somehow at the end of the day give Black people an opportunity to elect candidates of their choice and not be diluted and not be, canceled out of the process, we'll take it. We don't care how we get there. We just want a fair map. So if the court feels more comfortable with a certain type of map or the map being drawn in a particular way, let's do it. But let's not use that concern to rewrite the law. Let's not use this ridiculous suit that was brought to challenge the map as a vehicle for in any way undermining the crown jewel of civil rights legislation. That is the problem.
Yeah, and in this Milligan case where the Alabama's congressional map that the one that allowed for Shamari Figures to now join us, and in that case, you had, well, I was at least surprised by the votes of and the opinions and the alignment on the issue with Justice Kavanaugh, Brett Kavanaugh, and Chief Justice John Roberts. I'm interested to hear your perspective on the line of questioning they asked today, and if to you it signals anything one way or the other about where they might fall or where they see a distinction between the Milligan case and the Calais case.
Yes, I have to give a shout out to our Milligan case because that's a case that LDF litigated as well. One of our amazing attorneys, who's one of our directors of litigation, Duell Ross, argued that case, Allen versus Milligan. And it is a case that has set all sorts of other litigation in motion since then because it really made it clear what the standards are for proving when there's racial discrimination in the districting context. So, I mean, what the questions today suggest to me is that maybe, and Justice Kavanaugh was kind of transparent about this in his concurrence in the Calais, I'm sorry, the Milligan
Milligan.
decision initially, and he said, well, maybe Section 2 can authorize race based remedies, but maybe it can't do it indefinitely. Maybe this can't go on into the future with no end in sight. And so some of his questions had to do with what type of time limit should we put on Section 2? My argument is we don't put a time limit on a statute. A statute is there when you need it. When there's a violation, you can bring a suit under the statute. If there's no harm, no foul, there's no violation, no lawsuit, nothing. And that just having a law on the books doesn't harm anyone. And in fact, it helps the ultimate cause of ending race discrimination voting because it tells potential violators, if I do this, I may run afoul of the law. So let me stay on the right side of the line. And I don't see any harm in us keeping Section 2 on the books and us using it less and less frequently as needed. I don't know if Justice Kavanaugh was convinced by that argument. I hope that he was. I think it makes a lot of sense to me. But we'll see. We'll see if he thinks that it's necessary to say maybe 25 years from now, maybe 2, 3 districting cycles from now, we'll have to have Congress think about it again. But the other argument that we made, which I think is really important, is that it's not the court's job to decide when a statute ends. It's Congress's job. I mean, there's a separation of powers for a reason. So if the court is saying we think there should be a limit, it should give Congress an opportunity to determine what that limit is, to base that on a record of evidence that says, what do we need? Do we need 50 more years? Do we need 20 more years? Do we need, 10 more redistricting cycles, 5, whatever it is? We can't just pull these numbers out of thin air. It should
Yeah.
not be just based on what I say or what Justice Kavanaugh thinks. It should be based on evidence, and it should be based on some considered reasoning by people who were elected to represent us and make our laws.
Do you think that we're in this mess though a little? And I do think it's mess because I think the misnomer is that people think you want to be going to argue this case. I think you want to be saying this is settled law and I'd rather go, or not saying you done arguing, but you rather go argue something else. Like what is the evolution of this? Congress has refused to act since Shelby versus Holder. There's not been a Voting Rights Reauthorization Act passed even only under the Democratic majority. I think the Voting Rights Advancement and Reauthorization and Advancement Act was passed twice by the House and not ever considered in the Senate. Or no, when it was considered in the Senate, it failed. And so there's not been any bipartisan effort by Congress to reauthorize. So it feels like the Supreme Court is like, okay, well, they're not acting. So let me fill this vacuum, even though that's not what their branch of the government is supposed to do. I think that is a little scary. And I do want to know. I hope this is not a dumb question, but I want to know, and I want people at home to know, why would the Supreme Court want to rehear arguments in this case? What do they think is so significantly different from Milligan, which I know is a different set of issues, but pretty doggone close? Like it's Alabama versus Louisiana. Louisiana got more black people. Maybe that's the biggest difference, but I want to know why they wanted to rehear it. It feels, I'm nervous that it's like, are y'all trying to undo what you just did? The record is very clear just from a couple of years ago.
That is not a dumb question at all. That literally is the $1 million question. I mean, it is something that made us scratch our heads when we got that re-argument order in June of this year, when we thought, our colleague who argued the case initially did a great job. We expected that we would get a decision, and instead they said they wanted to hear it again. And so all we can think of is that obviously there weren't enough votes to conclusively decide the case in June, and they wanted to hear more. I do think that this issue of whether there should be a time limit is part of what was animating the conversation here. But it is truly so closely aligned with the Milligan case that it's just hard to imagine. The court typically doesn't take cases that can be easily decided based on precedent. They're supposed to take cases that are novel theories of law, or where there's a circuit split, right? Where half the country's applying the law one way, half the country's applying it a different way. So the Supreme Court has to come in and tell us what we should all be doing. There's nothing in this case that makes this really Supreme Court worthy, or certainly re-argument worthy, um, other than a concern that they might do something wrong. I hope that we cleared that up today. I hope that they understand that the consequences are potentially too grave. And those are not only the practical consequences of what may happen to elected representatives across the country, but also the legitimacy of the court is very much on the line, because their last decision was a mere 28 months ago. And so to reverse course now, when nothing has happened in between those 28 months, but an administration change, just doesn't bode well in terms of how people might perceive of this decision.
Janae, we have a question from the audience. Almond Joy, that's cute. Almond Joy, the question is, what are the options or next steps if SCOTUS rules to strike or weaken Section 2? I think that the question really is on recourse. What recourse do we have if we don't have Section 4 protections as much that they've changed it? Section 5 is in the pre-clearance section is virtually gone. What do we have left if we don't have Section 2?
Yeah, it's gonna be very, very tough. We always have the Constitution. We do have some state voting rights acts. We have other areas of law that we can rely on. But what it's going to do is make uh, districting much more manipulated, and it means that these upcoming midterm elections, I know that they are incredibly important as we sit here right now. They will become even more important, because it may be the very last election that we get on fair lines if we don't wind up electing a Congress that's going to pass the John R. Lewis Voting Rights Advancement Act or the Freedom to Vote Act. That is that has got to be the centerpiece of the elections as we head toward them, no matter the outcome of this case, to be honest. Because even if we win, as we should, and as I expect we will, because that's what the law says, there's still a lot of work around our democracy that needs to get done, and we do need stronger laws in order to get there.
We definitely do. There's another question about who's leading these lawsuits, and one thing I also want to flag is in this particular case. I started listening to the Solicitor General's arguments from Louisiana. In this particular case, it's pointed out, I believe it was by Brett Kavanaugh, saying, well, what made you switch sides? And I want to actually hear your answer on what you think the reason for the Solicitor General, for the Louisiana state to switch sides on this case. Why do you think that happened?
Well, I think that Louisiana switched sides because they saw an opportunity to get out from under the Voting Rights Act and having to comply with the law. They switched sides from the standpoint of saying that the law, that the map that they created is something that they wanted to continue to defend. So they were always opposing what we said in terms of the discrimination. They just remember they were the original discriminators, so they were always saying, "Hey, we did nothing wrong," until we made it, policitely clear that they had violated the law. And then they did draw a new map, and they defended that map, and we were glad that they defended that map because we think it is a fair map. They switched sides, I think, only because they saw an opportunity in this re-argument to try to push the court to do away with any obligations. And in fact, what's most disturbing, which I'm sorry I didn't get a chance to really tease out in the argument, is that they actually admit in their brief that there may, it may be that we never get rid of racially polarized voting. It may be that we never end residential segregation. And so that means that Louisiana is going to have to comply with this law forever. Yeah, that's right. That's right. If racism continues to plague our society and make our electoral processes imbalanced and unfair, you're right. You are going to have to continue to follow the law and make sure that Black people aren't always on the losing side of the stick. And what you should be saying is, we're going to do everything we can to end these factors that make our electoral process unequal and unfair and unbalanced, as opposed to saying, whining about the fact that you might have to continue to comply with the law. So that to me was the most damning part of their argument, and should give the court a lot of pause and disturb the court, that they're saying basically this could go on forever, and we wouldn't have to do anything about it.
That is the part. I'm glad you got to say it here. Breaking news, y'all. I wanna just ask you um this. Somebody is, and I know that there are folks that are watching everything that's happening throughout the country right now, and it gets really discouraging and overwhelming. I was already discouraged when they, gutted VRA in 2013, and now it feels like they don't want us to have any protections left. There's some folks sitting at home right now, Janae, who voted because grandma told them to in the last election, and they're like, what does it do? Like, I'm watching someone who looks like they're legit, like deliberately trying to cause harm to people who look like me, and now the court where this man has been able to appoint, three justices, they're trying to cause me harm. And when I look at my state legislature, I don't see people who are making decisions that make life better for me. What is the urging that you give to someone to continue to get up, to go to the ballot box, and to fight a little longer when they're not seeing that change they so desperately need and desire?
Yeah, that is such a good question, and I guess there are a couple of answers. One is that all of that proves the importance of elections, right? Who is sitting in the White House matters a ton. It matters, who we wind up arguing before when we go to the Supreme Court. It matters what executive orders we now have to navigate and fight, right? So who winds up in the White House is actually extraordinarily consequential, not only because of the policies that come out of the White House, but the power that the president can wield in other parts of government. The other piece of this is that people think that when you mail in your ballot, or you go to the precinct and you pull down that lever, that you can then walk away and think that everything is going to be all right, and that the people you put in office are just going to do right by you.
Mhm.
That is a very naive way to look at politics. It doesn't factor in accountability. It doesn't factor in the fact that democracy is an active sport. You've got to call on your representative and tell them exactly what you want. You have to, be in their face, go to their town halls, write the letters, be engaged with an organization, like ours or others that are doing advocacy, so that we can amplify your wishes and make sure that elected officials are aware of the priorities of the Black community. I mean, it doesn't end with just casting a ballot. I know that, people talk about the right to vote, and I'm one of them, that how all powerful it is. And it really, really is. But it is just the entry point, right? It is one power that we all have, but it doesn't end there. We have got to engage, and we've got to hold people to account. And if you don't like what your state legislature is doing, then or legislator is doing, then get them out. But the other thing, we've got to recognize that it's not a single person can just change everything, and
Mm.
that's why getting additional districts matters. That's why making sure that we use every bit of political power we have is so critical, because one person in a body of 30 is not really going to be able to make a difference. But the more influence we can have across, more districts and with more representatives, the better we might be able to get outcomes that really matter for our community.
I love that. Today you argued a Voting Rights Act case. When you consider what is before us right now, if you had the top three civil rights issues that you think not just our community, but the country should be paying attention to, what would they be?
Well, again, voting rights is
Yeah.
definitely number one, because it is, the gateway, I think, to everything else. I'm also extraordinarily concerned about the abuse of executive power. I'm extraordinarily concerned by how uh, the Trump administration is wielding military power, using the National Guard to bombard Black communities and cities, and especially Black-led cities, with violent militaristic operations. I think it's sinful, horrible, amoral, and certainly deeply unconstitutional, and something that we need to. I love seeing what's happening in Chicago. I love seeing some of the pushback, and we need to be much more united on that. Um, the other concerns that I have is obviously, immigration and ICE, and the way that, again, um, our own government is being weaponized against everyday people who are just trying to make a living and a life in this country. And that in and of itself should be enough to give all of us pause and make all of us, turn out to the streets and protest. But when we think about how that can easily be turned into a way to terrorize even people who are lawfully in this country, even people who have, done absolutely nothing wrong. It is actually quite scary and alarming, and that is another area where I just don't see, I think, enough, enough concern, uh, that, and I don't know that people understand what what that could potentially mean for all of us if we let
Yeah.
this continue to happen unchecked.
Yeah, one thing that was recently put on my radar was the undermining of the disadvantaged business enterprise rules at DOT. Taking out race and gender considerations for DBEs is going to be detrimental, not just to our community, not just to white women, but to the economy. So I
Hmm.
think the other thing people don't always consider is the clear overlap between civil rights protections and how students are educated, what books we can read, where we can go to school or to work or
That's
what
right.
contracts we can qualify for. So I'm so grateful for your work, dear sister. We always end our podcast with calls to action. And I know folks at home want to know, okay, I might not be admitted to the bar and certainly not to admitted to practice and argue before the Supreme Court, but there's something they can do at home. What would you offer them?
So everybody needs to join up with something, right? I mean, it's easy to sit at home on our couch or have our screen right in front of us and just scroll and feel like we're doing something and we're staying connected. But unless you are part of some sort of movement, whether it's, your local, NAACP, or your, whatever organization that suits you, a local community organization, something that, resonates with you and your identity and some of the issues that you care mostly about. We all need to be linked up with something and with other people who are doing something to change this moment. That is key. The other piece is you have to be prepared to vote and exercise your power. I mean, that is serious. You need to bring other people with you. You need to make sure that people are prepared. If it takes a passport for you to vote, get a passport. You don't have enough money, let's find a way to get you one anyway. Let's figure it out, because when we get up on these midterms, We know that there's going to be a lot of challenges. There may be changes to the laws of, what the proper identification is or whatever. Let's get out ahead of it. We know this is happening. We know that they will do anything possible to keep us out of power. So let's get out ahead of those things. And then I would say, find a way also to make your protest known and visible. There are so many ways to do that, even if you can't physically turn out on the streets, or there aren't protests happening in your neck of the woods. You can always use the power of your purse, your pocketbook, your Apple Pay or whatever you use as your e-commerce. Think about ways where, if there are cities and states that are not serving us well, or that are issuing policies, or that are complicit with a rogue government, um, withdraw your funds to the extent that you can. If there are businesses that have turned their back on DEI, stop it. I know we all love the convenience of different, entities out there that give us things immediately next day, or, a store that we all love to go into. Now's not the time for convenience or luxury or comfort. Now is the time for us to figure out, what is it that we are willing to sacrifice for our freedom? What are we willing to sacrifice for, even if it's not our own personal freedom, for the freedom of our community, for the freedom of our most vulnerable members? And everybody should be, there should be at least five things that you are not doing anymore that you used to do, because you know it's the right thing to do in this moment. If this is still business as usual, you're doing it wrong.
Love that. And it is so true. Janai Nelson, everyone, my good sister, who I'm very proud of for arguing before the Supreme Court today. We are in an era where we need to cherish and honor, celebrate, lift up, and pray for our heroes. She's certainly one of mine. Janai, how can folks learn more about NAACP Legal Defense Fund and where to find you?
Wonderful. Please go to naacpldf.org. Follow us on all of our social channels. We are on, Threads. We're on Blue Sky. Of course, we're on IG. We're also on that old, ancient, terrible platform. We're still there because that's where we still get a lot of our information out. And then you can find me on all of those channels as well. So, please get engaged, and we are a trusted information source. So
Yeah.
I know there's a lot of dismiss and malinformation out there. Count us as a place and space that cares deeply about informing Black people, educating Black people, and hearing from Black people. So please, please connect with us.
I love it. Thank you so much. She is the president and director general of the NAACP Legal Defense Fund. She's also a historical argument maker before the Supreme Court today. And let me tell y'all, if they are smart, Janai Nelson will win this case. Okay. So a shout out to you, good
Thank
sister.
you.
We're so grateful for everything you do. Y'all, please make sure you support the NAACP Legal Defense Fund. If we do not, we cannot have sisters like her arguing before the Supreme Court when we know it is in our best and highest interest. I am also stealing malinformation per usual. I'm stealing another term from Janai Nelson. She's also the person that said people power is what defines democracy. So we will continue to protect our power as the people. And until then, y'all, welcome home.
Thanks, Angel.
Native Land Pod is a production of iHeartRadio in partnership with Reason Choice Media. For more podcasts from iHeartRadio, visit the iHeartRadio app, Apple Podcasts, or wherever you listen to your favorite shows. I hope they can hear me say they got the wrong ending and the wrong ending twice. I hope the people know we added a fourth co-host. I hope they can hear me on this live fussing at y'all. That's why do we have this old ending? My goodness. All right. Well, next time let me sing the ending.